before we go and sleep waiting for tomorrow's ruling, I just want to put it into perspective that tomorrow's ruling doesn't mean that is the end of the case, as the judge highlighted it. Whatever the ruling will be, the trial will still continue, the main trial. And it can happen that some witnesses who testified in the main trial also testified in this trial within trial. It can happen that those witnesses who testified in this trial within trial may also be called in the main trial. For instance, the lead investigating officer and also Makubo. What is important is what impact will the ruling have on the main trial. We are in 2024. However, we are talking about the precedents of cases of 1965, which they deal with trial within a trial. I think someone must be brave and stand up and argue the fact that those cases, which mostly the Honorable Court referred to them, were decided before the constitutional state. And we are not sure if the principles adopted during that time, they will stand the test of the Constitution. However, the outcome will be tomorrow, the ruling. The trial, the main trial will still continue, but what is the most important is, should the ruling be that confessions are inadmissible, the state will find it difficult and will have a mountain to climb to prove its case beyond reasonable doubt. Even though the ruling is temporary, the court may in future change its mind on whatever the ruling they make tomorrow. But I guess it needs to be contested based on the constitutionality of those kind of rulings. Remember, the case law is not a statutory law, it's not law of parliament. Case law is precedent. It's a case law is created by events, it's created by the outcomes of matters in courts, and they act as persuasive factors. And some courts, they refer to old cases. With due respect, some honorable courts, they will refer to old cases before 1994. And the question is, are they still applicable during democracy? Hence, even the Criminal Procedure Act 51 of 1977 is being amended now and then. And remember, there was a conference, a national conference, to amend the Criminal Procedure Act 51 of 1977. Sometimes it's being referred as Criminal Procedure Act 51 of 1977 as amended. Should the Honorable Court a ruling that confessions are admissible. I don't think it will be much transmesh towards the defense, because the defense duty is just to create a doubt in the state case. It is still the duty of the state to prove its case beyond reasonable doubt. However, such ruling may lead to the state relaxing and thinking that they have everything in the bag. As the Honorable Court did highlight, and it was tempted to give judgment on Monday, it did highlight that it will consider that ruling as temporary, hence it's not a judgment. Judgment, according to the Honorable Court, with regard to the trial within trial, will still come at the end of the main case, when the Honorable Court will make an overall ruling and make judgment with regard to main matter and trial within trial. So I just want to make the public aware that under the circumstances, let us not put the horse before everyone, thinking that things will go smooth. Let us not let our horses out there. Let's wait and respect the Honorable Court, and let the Honorable Court apply its mind on the matter. Whatever the outcome the Honorable Court gives, and one of the parties feel that they're not happy with the outcome, they know the procedure. There are procedures in place for those parties who feel that their ruling is not in their favor. They know what to do, and there's no need for us to go on social media and call names and play the player and not the ball. We need to play the ball and not the player. I just want to make it clear. Me, TTThobane, all my social media channels are there to assist. I'm not there to take sides. I'm there to assist. I'm there to contribute with the little knowledge I have in law, and I'm there to learn from other people, as we always learn every day. And please, let's not put the cart before the horse. Let's wait for the outcome, and we will take it from there. That is with regard to the matter of Senzo Meyiwa murder trial, the ruling on trial within trial. And then I want to say something with regard to the matter of Sfiso Mkhwanazi. I think on the face of it, the judgment was fair. And as I said before, that before they sentence the accused, they need to compile reports, all kinds of reports. The accused need to be assessed. And that is what the court ordered. with regard to the precedents I've seen in our South African courts, that they show the faces of the accused when they appear. The Honorable Courts should make an order that the media must not show faces of the accused in the event that there is identity parade or witnesses coming testify in court. Because by that time when they come, they should have seen faces of the accused. I've seen it happened with the Mande brothers in Eswatini. It also happened in the matter of Jocelyn Smith disappearance. As you have seen what was happening out of that court in Cape Town, members of the public were baying for the blood of the accused. Only to find out when the matter started, the state had to withdraw the charges against accused number 4. The lady who was paraded by the state in the first appearance and have to spend 7 days in prison, if it's not less, only to come back today and charges against her were withdrawn. What the state did there, they put her life in danger, and including the life of her family members. I think the state must try to be cautious when it comes to allowing the media to flood faces of the accused. We're not saying the media must not go into courts, but we're saying as a cautionary rule, as a caution, they must avoid showing faces of the accused, especially in this kind of sensitive matters. Let's say, for example, accused number 2 in the Senzo Miwa trial. Another trial, he goes and makes an appeal in regard to bail, and the court gives him bail. What will happen to him when he's outside there? Those who are on the other side, those who are against whatever his point is, those who believe somehow about the allegations against him, they might try to do something and put his life in danger. Sorry for that. Same goes to the instance whereby they are found not guilty and discharged in the main trial. And we don't deny, I'm not against the media. I'm not against the rights of the media. They'll tell you that during the first trial before Honorable Judge Maumela, I was fighting for the media to be given access. But there is a limit. They must draw a line when it comes to the rights of the accused. Remember, we try by all means to make sure that the accused get a fair trial. I'm here for justice. I preach justice. I don't take sides. If the police do their good work, they must do it proper, and they must not implicate wrong people to avoid situation whereby wrong people are being arrested, detained, charged, prosecuted, convicted, and sentenced, only to find out after some years the truth comes out. And in fact, those people were wrongfully sentenced, or they were wrongfully convicted and sentenced, whereas the real people are out there. And ladies and gentlemen, I think the load shedding will be coming soon. I thank you very much for watching. Before I go, I'll try and go through your comments and see if there's any questions which I can answer. However, if there's none, when I post this video, you'll be able to post your questions and I'll answer. Please don't forget to like, comment, subscribe, and send us super thanks so that we can grow the channel and raise money, raise funds to buy proper equipment and have also community outreach programs. Let me try and check your questions if they're there. Mr. Derek SM Zubuga, you're welcome. Confession that 1 and 2 are finished. No, sir. As I said, confessions will not mean that. The trial will still continue and the state still have to prove its case beyond reasonable doubt. I don't know when you say confession will mean that 1 and 2 are finished. We are saying if they are admitted, no. The state still have to prove its case and the Honorable Court will still have to come back in the later stage to make a judgment. Tomorrow there will be a ruling, whether they accept them or not. The most important thing is confessions of accused are not admissible to co-accused, meaning confession of accused 1 won't be admissible to accused 2, 3, 4, and 5, and confessions of accused 2 won't be admitted to accused 1, 3, 4, and 5. Tessa, however, I want to hear what are you disagreeing about. Maybe we can help each other. There's no problem if you disagree, but let's raise your point and then I try to answer. Unless I already answered on your third point. Confession that tomorrow, whether they admit them or they don't admit them, doesn't mean the end of the case or the end of accused 1 and 2. The state still have to proceed with their case. Linduet Thala. What is your thought about the ruling? I cannot preempt now. We must respect the court. Let's give the court space to make a ruling. But as I did give highlights, I try to give hints to say either they admit them or they don't admit them. The state case will still have to proceed. The trial, the main trial, still have to proceed. And remember, whatever the outcome is a ruling, Lindwe. It's not a final judgment. The court can come back at a later stage to make a final judgment. The court still have to come, in fact, at a later stage to make final judgment. And the court can change, can give a different judgment from the ruling it gave. The court can give a different judgment from the ruling it will give tomorrow. Montakabula, I hope I called your name correct. One thing that puzzles me is that Danzo was illiterate, but he was able to fire you, not Uchiago. No. I think you got it wrong there. If an attorney and a client has a disagreement, then the mandate must be terminated. People might call it being fired, whatever, but attorneys don't work for accused. Attorneys don't work for clients. They enter into an agreement. Shimani Mkize, if confessions are admitted, will Kelly be arrested as a matter of mind? If remember those confessions, tomorrow it will be a ruling. It's not a final judgment. Then it will be up to the state. It will be up to the state what they do. If the state doesn't call Ms. KK in the main trial, they can give the defense the witness, and then the defense can call Ms. KK in the main trial. Remember, whoever the witness, the state doesn't neutralize, the defense can neutralize. Good. Kuti, in your opinion, why the state did not call Mchiako and Kelly? Because they were going to be under immense cross-examination from the defense, and which might have led to the collapse of the entire state case, including the main trial. They were scared that they would be exposed. The defense was going to poke holes in the state case, because it was very important for state to call Mchiako and Kelly Kumalo in this trial within trial. Ms. Kelly was supposed to be called based on the affidavit read by Keninda. Mchiako was supposed to be called by the fact that it is the state witnesses, Gronje, who said, and the interpreter who said Mr. Mchiako was there participating, whereas the defense, the accused, said no, he was just sitting there. And the most important principle, it is the duty of the state to prove its case beyond reasonable doubt. I think I tried to answer all the questions. And I just want to go back to you, Tom. You say, however, I disagree with you. I hope I did answer you with regard to that point. I hope the next point you say a confession will mean that 1 and 2 are finished. I did answer you. I did say it doesn't mean that. When you say confession, maybe you want to say when confessions are admitted, it means 1 and 2 are finished. No, remember, it's not a judgment. It's a ruling. It's a temporary ruling. It's a temporary outcome. The court still have to come back at a later stage and make a judgment, whether the confessions are admitted or not admitted. It is temporary. Let's see what you say. Why didn't the defense get the bank statement from Tanzi alibi? Remember, here we are dealing with trial concerning confessions. The defense might get those statements during the main trial. And with due respect, according to my opinion, you are not going to be of any assistance in the trial within trial. Thokozani Dlamini, do you think it was wise for the defense to call Makubo? Indeed so. It was very important for the defense to call Makubo. However, they were suppressed. And with due respect, Mugomezuli never stood for his ground. He should have let the witness, not to cross-examine the witness. The most important question he should have asked the witness is, which some of the state witnesses testified about? And the accused did put it to the witnesses or the court when he was testifying that Makubo, when he arrived there in that office, whom did he found? You are supposed to ask that. It is correct that you found the accused number 2 and other officers. That's the main question the defense would have asked Makubo. But anyway, it's not the tense match. Same thing can be done in the main trial. I do believe that the defense will again call Makubo in the main trial. Penny Makadika. Why rather look like he becomes rude when it comes to Mshololo? I don't know. I cannot comment on that. Even though we all seen it, we have seen it, but we don't know what's happening behind closed doors, or whatever is happening when they are in the chambers with the honorable judge. So I cannot speculate. Letu Tellers, thank you. We are learning. You are welcome. You are welcome, Letu. That's the purpose of my channels, is for me to learn and pass knowledge to the people. I'm not perfect. I can't say I know each and everything, but I can contribute, I can assist where I can, and I can also be assisted. Remember, as a lawyer, you must know where to find the law. I cannot be able to remember all the acts from 1910 until now, all the cases from 1910 until now, but I must be able to articulate, and I must be able to know where to find the law. If I remember a case law which will come to assistance, I must be able to mention it. Yes, ladies and gentlemen, please press the like buttons, subscribe, and like, thumbs up, so that we can grow. Letu Tele is, why can any action be taken against Rata? He is biased. Letu, remember, legal practitioners act on instructions. And a case before a honorable court doesn't belong to legal practitioners. It belongs to the clients. If the clients feel that they are prejudiced, they are the ones who must raise an issue. Legal practitioners cannot just stand up and come up with a point. However, in rare situations whereby things become personal between the presiding officer and the legal practitioner, it is very important for a legal practitioner to approach the clients and take instructions from the clients. As it stands now, I cannot say much with regard to your question, because it is not in my hands. It's not in the hands of the legal practitioners. It is in the hands of the clients. Just for example, even the clients, when they feel that we're not happy with this legal practitioner, or the legal practitioner notice that there's a conflict between the legal practitioner and the clients, then they come to a conclusion that they must part ways and a mandate to the legal practitioner be terminated. It's the same situation. And remember, if such an application is made, sorry for that, if such an application is made towards a honorable judge or presiding officer, the same application, it will be dealt with in front of the same presiding officer before it can go any further. And it is the same presiding officer who must make a ruling on any kind of application before the honorable court. Yes, ladies and gentlemen, I think it's time up for me, and I'll hear from you after this video is being posted, and you can send comments, any further questions on the video, and I'll be able to respond. I just hope that things went well with Defu today in court, because he was appearing in Johannesburg. I could not go as I was busy with other matters of my own. Thank you very much, and good night.